Welcome everybody to the very first SABU First Amendment Committee webinar with the astonishingly grabber headline of the Gagging of America. I thank our team for coming up with that name. The First Amendment Committee is one of the many activities of SABU, the Society for Advancing Business Editing and Writing. It was really the brainchild of our former president, Mark Hamrick, and then our founding chair, Marilyn Giwax of NPR. I know many of you know her name. Marilyn came up with the idea of providing statements from time to time on behalf of business journalists. And we've put out a number of these statements. We've revised our process a bit so we can do them. We can turn them around a little faster, but when business journalists are arrested here in America or overseas, when there are important issues about access to government records and other issues that seem germane, we speak out. We've teamed up with other journalism organizations. A lot of the production of these statements comes about thanks to our wonderful executive director, Kathleen Graham, who I know is in the audience, and SABU staff, including Tobin Ernst, who's kind of running the show here today. We have an idea perhaps to continue the webinar series. We'd like to hear from you about your ideas. One idea that's kicking around out there is the nasty habit of FOIA request ghosting, where organizations just stonewall responses to FOIAs and we never hear, hoping that we will go away. Today's program on the Gagging of America was really the idea of two folks. Our Q&A team, as it were, who will be here today, asking the questions will be Matt Drange, senior correspondent based out of Business Insider San Francisco Bureau. Matt reported on money and power in the Silicon Valley for Protocol, The Information, and Forbes, and the Center for Investigative Reporting. He's gotten dozens of awards, including SABU's Larry Berger Award given to the best young journalists, best young business journalists, and the best young journalists in America. Matt sits on SABU's First Amendment Committee, along with myself as chair, and JT Medor as of Newsday and a SABU director, governor, I should say, as vice chair. And then our expert today is Frank Lamonte, a professor at the University of Florida there in Gainesville, where the leaves have sort of fallen off the trees. He teaches media law and runs the Breckner Center for Freedom of Information, a think tank focused on the public's right of access to civically available documents. He's considered one of the top First Amendment legal experts in the country. He's practiced law. He clerked for the 11th District, for the 11th Circuit Court of Appeals. He was executive director of the Student Press Law Center in Washington, D.C. And before that, he was an investigative journalist and a political columnist. We're really glad to have him with us today. I will start out a couple housekeeping things. First, this is being recorded. Second, put lots of questions in the chat. We will try to get to all of them at the end of the program. And I'll use the moderator's prerogative to kick this off with a brief anecdote. On the day that Steve Jobs died, dozen or so, 15 years ago, an advertising agency in San Luis Obispo, California, posted a brief tribute to him online, which we picked up and published along with other comments from tech folks in our area. We got immediately slammed by the ad agency saying that Apple's lawyers were on them for violating an NDA. And if we didn't take down the quote, the woman who drafted the brief statement would be fired. So with that, Frank, Matt, take it away.
Thanks, Henry. And thanks everyone for being here. As Henry mentioned, we are recording this, and please, we'd love to hear your questions. So if you have some, we're gonna have lots of time throughout the conversation. We have some time at the end for that, but also we're happy to take some sooner. So please just fire away. I wanted to say too, it's pretty neat for me personally to be talking here to Frank. Frank was one of the folks who kind of first introduced me to the power of public records as a student in his previous life at the Student Press Law Center. And I kind of see the topic for today as sort of an extension of public records, in that it's about public speech and the guardrails that powerful interests want to place around them. So I think, and Frank, we're going to dive into a lot of this, but maybe if you could just start briefly by talking about how you first started researching, this topic of gagging of employees.
Yeah, and if you don't mind, let me go ahead and share the slides that I had prepared, just to have a little something for people to look at that is not my unpleasant face. Thanks very much, by the way, to all of you, but especially to Matt for organizing this. And I think that this is going to be part of an ongoing discussion and collaboration to work on sort of raising awareness about the problem of the silencing of employees in the workplace, and also the possibility of being able to push back against it. And so when I first came to this job at the University of Florida in 2017, I asked around to the people that I knew who were journalists or lawyers representing journalists, knowing that I was about to go into this think tank researcher environment. And I asked, well, what are your pain points? What are the things that are the most habitually getting in between you and the information that you need? And just overwhelmingly, people said, no one on my beat will talk to me anymore. And people who had been at it for a while were able to reflect with some perspective that this was like a relatively recent phenomenon, that, 20 years or 25 years ago, you could go knock on someone's door at a workplace and plop down on their sofa and open up your notepad and get your recording device and ask them some questions. And, you're free to do that. And that's where you got stories. And that all of that access had been shut down by PR gatekeepers. And this is both in the government sector and in the private sector. But as a researcher, I first started diving into it in the government sector, because after all, that's where the First Amendment applies. And so that was myself and a newbie lawyer, just graduated, Linda Norba, and I started to dig into this subject to try to prepare what we thought would be some talking points for journalists and their lawyers about how to push back against these gag orders on public employees. And we were actually really pleasantly surprised. Sometimes as a lawyer, as a researcher, you go diving into the law and you find out that it's not as helpful as you hoped or you thought. But this was really a gold mine when we started to dig into the court cases where people had actually sued their employer over being told you're forbidden from speaking to the news media. People won those lawsuits every single time. Just decades of case law where police officers, firefighters, teachers would sue their employer, usually after they got fired or something close to fired, because they get caught speaking to the press. And just overwhelmingly, the federal court said, well, no, in the public sector, the First Amendment applies, and you cannot do that. And so let me just show you I'm showing you this example, right? Why this is kind of front burner today is, of course, now the number one topic on which there is this friction and tension between journalists and government agencies is the pandemic, right? People want to go to, whether it's the CDC or their local public hospital, and ask questions of the researchers, the scientists, the doctors, the nurses, the EMTs, the people that actually have firsthand knowledge and experience about what's going on the ground. And they keep being told, no, 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 you can't have any of those things. Here's a prepared statement from the PR office, and that's all you're going to get. And in fact, right, I got a headline from Bloomberg here. It was commonplace during the pandemic for there to be reports about, we tried to talk to the local hospital about the conditions there, and all the employees have been told that they were going to get fired if they spoke out. Well, when we started to dig into the First Amendment case law, what we found is that kind of the headwaters of the case law is in 1995 in a case called the Treasury Employees case. And I'm not going to make this into a law school lecture, so I'm going to really super bottom line this. But the Treasury Employees case is a U.S. Supreme Court case from 95, where the Supreme Court is asked whether Congress can pass a statute that forbids federal employees from accepting speaking fees. And the Supreme Court strikes it down. The Supreme Court says, no, that is an unconstitutional restraint on employee speech under the First Amendment, because what you're trying to get at is you're trying to get at some subset of invidious behavior where somebody might take a bribe because they have a sensitive government position. But this was a blanket restriction on all federal employees, and they couldn't even take, $50 for the most harmless, innocuous public speech. And so the remedy did not match the wrong, says the court, and this restriction was an unconstitutional prior restraint. And when you look at the federal case law where people have challenged these, what we call gag policies, they invariably win for that reason, because the policy is always too broad to do the job that the employer purports to be doing, and it always ends up infringing on whistleblowing speech and inhibiting people from just talking about their everyday workplace concerns. There's not enough parking, I haven't got a raise in 3 years, whatever, they're not letting us have overtime, all those things that the First Amendment ought to protect the ability to say in the government workplace. All those things would be restrained under these gang policies. And so time and time again, when people have gone to federal court, and again, it's usually they got fired or they got demoted or lost some pay, they win when they sue over being punished for violating one of these gang rules. So I've just excerpted a couple illustrative examples of the kinds of policies that the federal courts have told us are unconstitutional. Don't make unauthorized public statements. Don't speak to the press on any controversial matters. Don't make any comments related to department policy. All those types of buzzwords are going to be unconstitutional because they're vague and they're overly broad. And yeah, right, we know that these policies are everywhere. There's this real disconnect between the way that agencies are behaving and the way that courts are telling them to behave. And I think, your intuition, your common sense is telling you, well, why is that the case? Because employees don't typically sue, right? Like, what employee at the CDC, what employee at a state hospital is so motivated that, yes, I want to be on television, I want to give this interview, that I'm going to get a lawyer and spend 2 years in federal court fighting my boss, right? No one's going to do that. And so these things are kind of like a dead man walking. These policies, they're unconstitutional, they can't be enforced, but until somebody challenges them, they're there. And so, everyone is walking around acting like they're bound by these policies when in fact they're legally unenforceable. And,
Mark, I wanted to ask you about. I wanted to ask you about that and pause briefly. So, I often hear from a reporter, friends of mine and colleagues, I want to talk to employee X on my beat, but I can't, and they say they're not allowed. They'll get in big trouble if they do. Legally, is there a distinction between protected speech when it comes to blowing the whistle on some kind of misconduct, say, or fraud, for example, versus, complaining about your boss or complaining about a crummy job or a crummy product? Is there a distinction there with what is allowable?
Yeah, so I'm so glad you said this, because when we move to the private sector and the business sector, that distinction is going to come up again. But even in the law of the First Amendment, there's kind of, if you can keep two boxes in parallel in your head here, right? Box number one is when we're talking about a blanket prohibition on speaking, right? What's called a prior restraint, the kind of policy that was in front of the Supreme Court in that Treasury employee's case. That's in one box, right? A policy that just at the get-go says nobody's allowed to talk. That policy is unconstitutional. And if someone is punished for violating that policy, that person is going to win and get their job back lickety-split every single time, okay? But then there's another box where you're not punished for violating the no talking policy. You're punished for what you said in the interview. And that is kind of a metaphysically different thing, right? And in the law of the First Amendment, the fact that you're allowed to talk doesn't mean you're allowed to say anything, right? So there are certain legitimate, confidences that government can keep, right? You don't get to take, medical records or student records and just blast them all over the news media because you decided that they're newsworthy, right? You could certainly be disciplined for violating a confidence. And Matt, you mentioned the example of, right, if you just trash your boss sort of for no good reason, right? The First Amendment is recognized as protecting your right to speak about what are called matters of public concern. And that's the buzzword that the courts have always used. So if you're just belly aching about how you hate working at that agency, right? I hate working at the CDC, my boss is a bum. That's not constitutionally protected speech. On the other hand, if you're talking about conditions for everybody, right? If you're saying that, CDC underpays its employees, and as a result, we've had this brain drain of good people leaving, and the public is being ill-served by the CDC, that's protected speech, because now you're addressing something bigger than you, bigger than what's called a purely personal workplace grievance. So yeah, if you either do one of those two things, you compromise confidentiality, or you're just belly aching about a personal grievance, then you've departed from the protection of the First Amendment. Yeah, but that still leaves quite a lot, right? I mean, it leaves quite a lot that people can say. And the more that something looks like, particularly if it looks like you're speaking, right? And we always advise journalists this, try when you're trying to talk to people about, particularly if they're maybe going a little bit off script of their employer, maybe, in the hospital example, they're going to talk about the fact that I feel unsafe coming to work because the PPE is inadequate. Don't do it in the office during 9 to 5 hours. Try to get them at a coffee shop afterward. Try to get them at a time, when they can call you or text you back after work, so that it looks like there's some separation, from the workplace. Because the more that it looks like they're speaking as an individual and with their citizen hat on, the better protected they're going to be.
Yeah, we just got a question, I think, that kind of speaks to that too. So this is when I'm able to get an employee to speak with me, there's always a PR minder present on the interview. Can I demand that they go away based on the First Amendment? And can I get just this person that I want to talk to alone? And how do you do that? Frank, you just talked about how you could maybe do that practically speaking, trying to get someone off of work hours perhaps, or outside of the workplace. But aside from that, is there any recourse that a journalist might raise here?
Yeah, I mean, it's a very weird catch-22, right? Because once an employer, and again, now we're still talking about the government for the moment, right? We'll switch to the private workplace in a sec. But once the government sets up this gatekeeping system, so you call, let's keep using the CDC, call a CDC. You say, I need somebody that can get on camera for my TV news program that can address best practices for masking, right? And then the CDC says, fine, we got Dr. Jones here, come on over with your camera. At that point, then it kind of looks like they're acting as an official spokesperson for the agency, right? Because you asked the PR person to get me somebody who could speak to X issue, and they rolled them out for you. So they're probably not speaking in their citizen role anymore, and their First Amendment rights diminish at that point. So I think in that context, if you or the employee were to say, I demand under the First Amendment that you leave the room and allow us to talk alone, again, particularly if it's on the premises of the CDC during 9 to 5, like at that point, right, you have no more control over that room than they do, right? You don't own the room. So yeah, I think the answer is try to set those things up where the person comes into your studio after working hours, now you have control of the room, right? And if the PR people at that point say, at 6 o'clock after hours, I'm going to come into the studio anyway, you could say, no, you're not. That's my studio. I didn't invite you. I invited the employee. So yeah, I think that's it. You gotta just, there are both legal and practical matters here, but you're also raising a really interesting issue that, to my knowledge, has not been tested very much, but that I am dying to see put to the test, which is, does the journalist have sort of an independent, freestanding First Amendment right here, apart from the speaker? Because, after all, the speaker is the one who's in jeopardy of being punished, right? The employer, what can they do to you? But the speaker is the one who's going to get fired. So the First Amendment right is much clearer there for the speaker. For the journalist, it's really interesting. As a law professor, with my law professor hat, I think the answer is yes, that the journalist has a First Amendment right. And we've seen that applied in the context of a gag order at a trial, right? So Bill Cosby is on trial, and the judge says at the Cosby trial, no one at this trial can ever talk to the media about anything that went on in this courtroom. Journalists can go to court and say, that's a violation of my First Amendment rights as the recipient of the information, because I know the jurors are not going to sue you, Judge, but I'm going to sue you. I'm going to sue you on their behalf so that they can speak freely to you when the trial is over. And that's a totally legit lawsuit. So I actually think that there's a not zero proposition there of being able to sue on the employee's behalf. We just haven't seen it done yet. I don't want to get bogged down too much in public employees, though, because I do want to move forward. But if there are other questions, feel free to fire them off.
Yeah, we got one other. Actually, it's you brought up the Cosby case, which everyone knows. But this next question is what if a boss is accused of something like sexual harassment? Are employees protected to speak on that person without recourse? Of course, journalists must do their own due diligence, but I'm wondering if it's protected speech for the employee in a case like that.
So actually, to revisit something that you raised earlier, Matt, that I should have closed the loop on, you mentioned whistleblowing. Right. And I think a lot of people are under the impression that there is this generalized whistleblowing right out there in the law. But when you dig into the research, it's a little narrower than meets the eye. Whistleblowing laws typically protect your ability to blow the whistle up the chain of command in your own agency, or to something like a law enforcement agency or the state auditor or the state inspector general. So something that's inside the government, right? That's where whistleblowing laws typically apply. They don't, to my knowledge, I've never seen one that applies to the to going public on the news, right? For that, you have to fall back on the First Amendment. So whistleblower statutes are great for protecting the ability of people to complain internally, but they're not useful really in the media context. And I would never, I will say this more than once, I'm sure, I would never give anybody false assurance, right? I would never give somebody that I was going to put on camera on my TV news program. I would never say, don't worry about it. You got whistleblower protection. You're good, right? I've never given anybody false confidence like that. So going back to the question about, so if it's a public employee and they wanted to speak out about, I have not seen that exact scenario tested where it was the victim of the harassment. That person herself speaks to the media, gets fired, challenges it under the First Amendment. But I imagine those cases are percolating now because of Me Too, but I haven't seen that particular scenario conclusively decided, because that does kind of exist there in that gray area between, is this just you complaining about your own working conditions, or are you alerting the larger public to an issue of public concern? I would certainly argue as the, lawyer for the employee, right, that it's the latter, that, well, no, I'm not just talking about my own discomfort. I'm trying to make sure that this person is not dangerous to others. But has that been conclusively decided? Not to my knowledge.
Mm-hmm. Mm-hmm. There's another question that came in. I'm not sure. Maybe Henry, what this one's referring to, but and then we can kind of move on to the private sector here in a second. But just the last one on the public employee one for now. In my experience, public sector employees are unaware of this or don't care. either way they ignore it when reminded. What would you suggest a reporter do who runs into that?
Yeah. First of all, what I always tell people is publicize the gag, right? I mean, particularly if it's an agency that you come up against on a regular enough basis that this is really interfering with your ability to get the news, right? I do a standalone piece just about that, just about the dubious constitutionality of these policies, you know? So that's number one, right? I would examine the policy, put it under the microscope and publicize it. Also, I would just demand of the agency to see the policy, because sometimes you find out, in fact, I'll give you a concrete example, so that the Chicago Police Department, if you look at the handbook for people who work at the Chicago Police Department, it's a perfectly good handbook. I couldn't have written it better myself. It clearly lays out the fact that employees of the Chicago Police Department are free to speak publicly about their own opinions. But does anybody at the Chicago Police Department think that's the rule? No, they do not, because the water cooler gossip is if you show up in the media, you get fired. And so the water cooler gossip has overridden the handbook. But people should publicize the heck out of the handbook, right? I mean, if I were at the Chicago Tribune or WBEZ, I'd be doing stories about the fact that there's this widespread misperception that people can't talk, when in fact, here's a PDF of the handbook which says go right ahead and talk. And so sometimes you find out that the policies and the rules are actually better than people have told they are, and they're perfectly constitutional, but no one is aware that they exist. So there's that. I would publicize if it's an illegal policy, or even better, publicize it if it's a legal policy, you know. And then you know, I think what I would also do is find ways, like we talked about with, you know, get people after hours, or you know, otherwise cultivate those source relationships where you're not relying on the PIO as the gatekeeper, because once the PIO starts to serve as the gatekeeper, then you're toast, you're doomed.
Yeah. Well, let's switch gears a little bit to the private sector, because I know a lot of this does apply, but it's, of course, it's different. Yeah, I have a few questions for you, Frank. But why don't you go ahead and start us off with that?
Yeah. So as Linda and I are digging into our research about the First Amendment rights of public employees, we start to learn more and more that, in fact, private sector employees have also brought successful legal challenges under the National Labor Relations Act. So these are two parallel bodies of law here. If you're in the public sector, you work for the feds, the state, the city, you've got First Amendment rights, period, the end. You're in the private sector, you have NLRA rights, period, the end. So no First Amendment for you, but the NLRA, interestingly enough, does not apply in the public sector. So these are exclusive bodies of law, right? And the NLRA, right, federal worker rights law, been around since 1935. The key buzzword of the NLRA is that it protects concerted activities. This is Section 7 of the NLRA, that anything that looks like it's two or more employees seeking to organize to improve their working conditions is legally protected, and if the employer infringes it, that is an unfair labor practice, and they can be sanctioned for doing that. Well, over the years, the board, supported by federal court rulings, has interpreted the NLRA to say that speaking to the press is part of concerted activity. And so if you, as an employer governed by the NLRA, we'll talk a second about who is and who is not, but if you as an NLRA governed employer have a handbook that either says nobody here talks without permission, or only say favorable or positive things about the company to the media, that too is regarded as an unfair labor practice, and the employer can be and has been required to rewrite the rule book and to alert the employees. No, we don't have a blanket. And these things have different nomenclature to them. Sometimes they're called a confidentiality policy, a privacy policy, whatever the nomenclature. If the effect of it is to inhibit people from speaking to the press or to anybody in the public about a concern about their work, that's enough to violate the NLRA. Now, you see my caveat here, right? There are certain threshold triggers for the NLRA to apply. Obviously, not a government agency, not a mom and pop, little dry cleaning shop on the corner. It's got to do a little bit of interstate business, but not very much. I mean, any of the big companies that Cebu members cover, you know, the Silicon Valley crowd, the big retailers, you know, the Walmarts, the McDonald's, all those people are all governed by the NLRA. Even private universities are, you know, Northwestern or Princeton or Duke are all governed by the NLRA. And also, this only applies to non-supervisory employees, right? So if Walmart tells the, you know, the vice presidents, don't you give any interviews without permission, they're allowed to do that. Those people are regarded as official company spokespeople, but the lady wearing the blue vest greeting you at the door, she's not a supervisor. She can't be gagged. So, and I'll show a couple of examples of this. And this is the biggie that I really wanted to flag, because once something is decided by the NLRB, it can be appealed by the loser into the federal courts. And this is the most recent of the federal court rulings that address this gagging issue. And it's quite recent. It was just a little over a year ago now, in 2020, in Maine. It's called the First Circuit Court of Appeals, right, which is New England and that region. And you see the backstory, right? This is Karen Cho Young. She writes a letter to the editor of the newspaper. This is, right, private hospital, private sector employer, basically saying, you know, once the new management company took over my hospital, the conditions went downhill and we had this huge employee turnover problem, and I'm worried about the effect on the patients. And she literally the next day, she's called into her supervisor's office. They have a printout of the letter to the editor, and they say, you're fired because you violated this confidentiality policy. And this is an excerpt from the policy. And I'm excerpting this because this is very typical of the policies that you see at businesses all over the country that you've probably encountered yourself. No employee can contact or release to the news media information about, that's the name of the health system, member organizations, without the direct involvement of the community relations department or the CEO. Very common type of policy, right? And the NLRB says, sorry, that's an illegal policy. And you both have to rewrite the policy, and you have to give this lady your job back. And the board decides it, and then the hospital appeals. And in 2020, the court comes back and says, yeah, we agree. This is an unlawful labor policy under the NLRA. So
did Karen, do you know, did she get her job back? I don't remember. I didn't follow up on that, but is she still there?
I think that what happened, because she was getting up there toward retirement age anyway, I think that what happened is that they, and this is just my memory, so don't trust it, please. Somebody go back and check it. But I think that what happened was that she got basically a buyout. She got basically a financial settlement, that she wasn't all that interested in going back to work anyway. And so I think that's what happened. But please don't quote me on that. Don't take that to the bank. But I think that's right. And honestly, often that's how those cases get resolved, because people don't want to have people back in their workplace who just sued them. So, but
right.
Yeah, the takeaway from that, right, is that a policy like this, you know, and we hear this all the time from people, even, you know, very experienced lawyers will say, well, yeah, I know what the law says, but we have our own policy here, and we go by the policy. And it's like, how nice for you, but you don't get the policy your way around the law, right? The law exists specifically to invalidate unlawful policies. And so that's a kind of a, you know, a so what response, right? When somebody says, well, we have a policy, it's like, well, so what? Your policy is inferior to the law. And so your policy is legally unenforceable.
What about, so, and I think this is something that's probably maybe top of mind for a lot of Cebu folks, with just how often or how common unionization has been in the news media the last couple of years. But what if Karen was part of a union? Does that make a difference in terms of her legal protections or lack thereof?
Not under the NLRA, it doesn't. Other than, I mean, obviously, right, there's contractual things that kick in when you're, you know, part of a union and you've got a collective bargaining agreement. But for purposes of the NLRA, it doesn't matter. And in fact, right, it doesn't have to be a union shop at all. Even if people at a, you know, right to work shop are getting together to try to improve their working conditions, or reaching out to the public for help in improving their working conditions, which is really what Karen was doing with that letter, right? That's still protected activity. So even though there was sort of no imminent possibility that she was going to, unionize or join a union or anything like that, didn't matter. Doesn't matter for purposes of the NLRB.
Got it.
Let me turn to one more case, and then we can really throw it wide open for the rest of the time, because this is one that's going on right now that I say it's a case to watch, but it may or may not tee up the issue of the gags, but I'll tell you the backstory to it. So everybody's well familiar with Tesla and with Elon Musk's propensity for tweeting things that he later comes to regret. And in the Tesla versus NLRB case, there are a whole bundle of workplace issues here that got in front of the NLRB, including the don't talk to the media policy. And there were complaints filed against Tesla by people who wanted to unionize, alleging various anti-union practices and policies at Tesla, like don't distribute literature on company grounds, don't wear, pro-union badges or buttons on company grounds, and don't talk to the public about anything regarding Tesla. And so for my purposes, right, this is the one I care about. In just March of last year, the NLRB comes back and says, yeah, that mandatory confidentiality agreement. And remember, sometimes it's called an NDA or confidentiality policy or privacy policy, whatever. Nomenclature doesn't matter. And it doesn't matter whether it's in something you sign or something that's just unilaterally imposed on you. None of those things seem to matter in NLRB land. And so if you have a policy like this in a handbook, even if the employee has signed something saying, yes, I agree that I'm bound by this handbook, which includes this policy saying it's never okay to communicate with the media about Tesla, right? Can't get any broader than that, right? I can't even complain about the food in the cafeteria. I can't say anything at all about Tesla without specific written authorization, right? You'll never find a broader policy than this. And then NLRB says, nope, too broad, out it goes. You've got to tell the employees that they're free to speak about their workplace concerns. The case is on appeal right now. The Fifth Circuit Court of Appeals is the region that has Texas and Louisiana in it, but this will affect the whole country. The reason I say this may or may not get teed up is I was just reading the briefs in the case that it's actually going to be argued any day now. It could be Monday, even before the Fifth Circuit. It's imminently going to be argued before them. And so far, the confidentiality thing is not at all central to the briefs. It's a lot of the other things that are being litigated, including, right, that Musk did some tweeting that was interpreted as discouraging people, trying to dissuade them from unionizing. And the tweets were regarded as an unfair labor practice because there was this implied, or else, like a fist inside of the glove here, that your boss is telling you, I don't want you to unionize, which NLRB frowns upon. And so I think that's really going to be what the case ends up being about. And it may be that the confidentiality thing doesn't get litigated at all, meaning that the NLRB ruling will hold up, the 2021 ruling will hold up, and they have to change the policy.
Yeah, I mean, I think that the Tesla one is really interesting. You obviously mentioned Musk. He's not afraid of controversy, and his background with the SEC, giving him a minder for his tweets kind of reminded me earlier, Frank. You mentioned the whistleblower protections and how they typically apply to public sector employees, but there are SEC whistleblower protections. There are key TAM lawsuits, which are rare. Obviously, it's not every day that one of our SABU members is going to be reporting on those. But how do those kind of fit into this context? And is the Tesla case an opportunity for any of those to come up and get
case are, well, there's really three, right? So there's Tesla, there's the NLRB, and then the UAW, the auto workers, have intervened in the case, and they're aggrieved by some of the holdings of the NLRB that didn't go the way of the union. And so that it's really turning out to be about unionization. And I think that's really what the case is going to end up being about in the Fifth Circuit ruling. And so the silencing of the employees, I kind of think that the NLRB ruling is just going to hold up, and it's just going to stay out there on the books, which for me, as a free speech guy, is good news. I want that to hold up. I mean, honestly, I'd rather have the Fifth Circuit decide it because the appeals court carries more weight to it, but I'm perfectly fine with letting the NLRB ruling hold up and having that good main case to point to as a federal appeals court case. But you're very right, that the NLRA is not the only ring in the circus, and there are a lot of other ways in which consequences can be imposed on employers. In addition to, you're right, SEC rules, there are about 40 states now that have some type of a statutory prohibition on overly broad NDAs. Specifically, a lot of them are directed at like Me Too issues or just safety issues, right? So if you are somebody who works at, an automobile company and you know that the cars explode and you violate the NDA by going public with the exploding vehicles, there are some legal protections in place for you that if the employer comes back and tries to inflict punishment on you under the NDA, that you may get forgiveness from that NDA. And the courts have there was a case about 2-3 years ago now called the Overby case. And this is in the context of the government again, right? And so I think government employee speech is more clearly protected, but I think it has some instructive applications or analogies to it. Overby case was an NDA case where a woman who is a police brutality victim in Baltimore gets a settlement, signs an NDA, and then kind of has remorse about it and thinks better of it and says, well, I am going to talk to the media about the way that the police behaved. And the Baltimore police try to take back the settlement money. And the federal courts say, no, even though she signed this, and normally contracts are regarded as enforceable, there are just some contracts we're not going to hold people to. And one of them is a contract against whistleblowing about police brutality. And so I do think that even though that's an especially compelling case because you had a government agency on the other side, and not just a government agency, the police department, especially compelling, I do think that, there are times when employees are going to be able to get forgiveness from those NDAs on kind of larger public policy grounds. Is this something that speaks to, a safety hazard that affects more than just you? And, so yeah, I think that's out there. Now again, okay, second time I'm going to say it. I would never give anybody that I was interviewing false confidence, right? I would never try to assure somebody, don't worry about it. The law's on your side. Employer can't touch you. Nothing's going to happen. I mean, as I've told people before, if you ask me if I go into the corner neighborhood bar, am I going to get punched in the face? It's like, I can't tell you you're not going to get punched in the face. I can tell you it's not legal to get punched in the face. I can tell you that you can go to the police and you get the guy arrested, but I can't say you're not going to get punched. There's every chance you're going to get punched in the face because people break the law.
Right. Yeah, I think that's sort of, I think one of the things that comes up the most among reporters who I talk to about this. It's sort of the optics of it, and Frank, you mentioned some of this new Me Too rooted law, like here in California. We've just expanded those protections to cover discrimination, race, gender, sexual harassment, those types of things. So if you're blowing the whistle on your own experience about that, you are protected. But it's just this very interesting dance, I think, that reporters often have to navigate with the source. And so I wonder, if you could offer any advice or insight, when it comes to dealing with someone who says, hey, I really want to talk to you, I want to help you with X or Y, but this is my situation, this is what I'm dealing with. Obviously, as a reporter, you can't just, like you were saying, provide them 100% assurances, but are there things you can bring up? Are there cases you can bring up? Or, what if I said, hey, this is how these some of these cases have been decided. Here's some context you can go read to kind of judge the optics yourself for the source,
Yeah, that's an interesting. I mean, honestly, Matt, I'm about to turn it back on you, and maybe you'll drop a link in the chat even because you and Insider have done some of the really definitive work on this recently about NDAs and the tech industry and how they're onerously broad and at times questionably legal. And maybe I should be asking you, Matt, how did you get all these people to talk? Because yeah, all of that, to me, all of that is really fraught business, right? Even just giving somebody a court case and saying, like, here, perhaps you'll find this reassuring after you read it, feels a little too much like, again, kind of inducing them to rely on, the safety of vindicating your rights after suing because, nobody wants to be unemployed for 2 years, right? And so I would hesitate to do that. I do think that it's better to just go frontally at the employers, right? And try to pull these policies up by the roots, right? It's like weeding your garden. It's better to pull them up by the roots than to mow them and find out that they come back, And if we can pull them up by the roots, if we could really challenge, and I will say, by the way, I'm going to drop a link in the chat too. This is one of the studies that we published here at Breckner, and I'll drop another one in there in a minute. It is not at all inconceivable that a news organization or a SABU or a Society of Professional Journalists or a National Press Club or a Reporters Committee for Freedom of the Press could file these cases with the NLRB because, right, the NLRB doesn't work like courts do. In court, you bring the complaint and then you are the proponent of the complaint, meaning that you have to pay for the lawyer and show up in court and, foot all the expense of fighting the battle. But in the NLRB, it's a little more like calling the cops, right? I mean, once you call the cops, you're not expected to solve the murder. You just report the murder and then you go on your way. And it's a little bit like that. You're reporting the illegality and then you walk and the NLRB staff takes it over. If they decide that the law was broken, then they bring the case. You notice the Tesla case was called Tesla versus NLRB. It wasn't Tesla versus whistleblower employee because the NLRB prosecutes the case. Basically, I'm using prosecutes in quotes because from the crime, but right. So in other words, the barrier to entry to blow the whistle on one of these illegal policies is pretty low. So I don't know of any precedent of a news organization ever doing it, but I also see nothing in the law that says they can't.
Yeah, so it's a great point. I'm putting a link to an example of that at Google where there was an NLRB case brought from a guy who was I think we call this a story by myself and we call him I think a right-wing provocateur. And it was a really interesting case, and we got a bunch of documents from the NLRB about it. But and I want to mention two things. One, we have about 10 more minutes, and we'd love to get other questions. And then, two, Frank, to your point on the NDA series that we did here at Insider, the biggest thing in getting copies of the agreements, I think, was granting upfront anonymity to people who share them with us, and that was the key thing. And that, we sort of felt like was the only way to get some of these agreements. And so we got about 40 of them. And we kind of let the documents, sort of to your point, Frank, let the documents kind of speak for themselves in a way. And we analyzed them and talked to legal experts about them and sort of published the takeaways of them. But there's just so much, I think, understandable risk for employees at big companies these days, like Tesla, where there's good reason to be afraid.
Yeah, and on the other side, people will ask, and if somebody hasn't already, they will ask, how is it possible that there is this disconnect between what the law says and what everybody is doing, right? And I think that, go on the highway. It's illegal to go 80 miles an hour, but everybody's doing it. People have decided that it's to their benefit to speed. And I don't think that the consequences are going to be all that great. I doubt very much I'm going to get caught. I'm willing to pay the small ticket if I do get caught. And it's the same thing in the context of, I think, both the public sector and the private sector. The public sector, they don't care because they don't pay for the lawyers. We do. So if the CDC gets sued because they're gagging their employees, we foot the bill for the legal counsel, so they don't care. And then in the private sector, the remedies that are available to the NLRB for one of these unlawful policies are really meager. I mean, the typical order says, just change your policies. just
right.
change of policy. So it's like the state trooper pulling you over and saying, don't speed anymore.
Right. That's what happened in that Google case I mentioned. The person didn't get their job back, but Google was forced to post the NLRB policies and revise their own. There's a broader kind of question here and a comment, I think, too, about just sort of the balance of power, if you will, right now, between not necessarily big tech, but big business interests in the media. Catherine says the human ability for reporters to just talk to people is so critical to understanding, walk around, chew the fat, get to know someone, talk off the record. We have come to the point that lobbyists, insiders, and other people with power have this ability. They do talk to staff during work hours, for instance. Have we come to the point that powerful have this important networking power, and journalists who report to larger audiences are cut out of that? Is this an oligarchy, essentially?
Well, so, and Catherine is a ringer here, because Catherine has been the national authoritative voice on the gagging of government employees for a very long time, and was out there beating this drum way before me or anybody else, and she's won national awards for it. And so she deserves a lot of credit for surfacing this issue and keeping it alive. But I mean, she's speaking to a really important, larger cultural thing too, right? Which is, and that is, when you're asking for advice or tips for journalists, right? That is like a concrete thing that I try to steer journalists toward, is if somebody says to you, like, we can't talk, or we're not allowed to address this or that thing, I would always push back on that, and also think about how you're phrasing that in your coverage, right? Like, I read this all the time. I read a lot of news. It sort of nails on a chalkboard to me when people say, like, we're not allowed to talk about ongoing litigation, or we're not allowed to talk about personnel matters. And it's like, that's not a thing. That's not a thing. You made that decision. That is your own policy not to do that. It is nothing. There's no such thing as a anti-personnel discussion law, And so that is your own. So to say, like, we're forbidden from, or we're not allowed to, or we can't talk about it. It's like, no, it's not you can't. You won't talk about it. And I do think that like nomenclature can matter, to give people benefit of the doubt that they're not entitled to and that they haven't earned doesn't help us, And so I would always think about, the very next sentence in the story being like, there is no law forbidding workplaces from talking about lawsuits against them, or something to that effect, that sort of acknowledges that, like, this is a made-up rule. This is a made-up rule. Right. I do think that the public is out there under the impression, because people have heard it said enough times, well, of course, no one's allowed to talk about pending litigation. Where did it come from? This is not a thing.
Right.
James has a really good question. As a lawyer, I probably should scream this one from the rafters, but obviously, do not do anything without talking to your own company's lawyer about when somebody were to say, like, if I get exposed as your source, will you provide the legal representation for me? I am not aware of news organizations typically doing that, and that would be a general counsel question for your media company for sure. But I am not aware of news organizations doing that, which is too bad, really, because the rights of the source and the rights of the journalist are joined at the hip. But I think that most news organizations probably will say, look, our obligation goes as far as not outing you as a confidential source. And if your employer figures it out some other way, they get into your emails or whatever, they figure it out some other way, then sorry, buddy, you got to go to your union lawyer.
Yeah, that's a really tricky point. It just, I feel like in my experience, just comes down to the only thing you have as a journalist for something like this is to say, look, I'll do everything in my power to keep your identity a secret, and is there any legal binding authority to that? No, and that's sort of a hindrance in a lot of ways. It's just, hey, I need you to trust me. I've done this before. This is how I do my job. It can be really difficult.
Yeah, we could do a whole nother hour some other time about reporter privilege laws and what is and is not protected confidence too. We should put that on the agenda for a future session.
Absolutely. But I think Frankie makes a great point, which is, when it's someone in a position of power at a company, to call it like it is, say, hey, you're choosing not to talk about this, whether you say that to the person or in your coverage. But then on the flip side, when it's the worker bee, if you will, saying, gosh, I can't do this, and this is what my company has told me. I'm not in a position to challenge it. It is a totally different dynamic. And it can be really,
they really may not be allowed. They really may not be allowed. Yeah. Although again, like the next paragraph could be, however, federal law says that workplaces, covered by the NLRA cannot.
Right. They may not be allowed by their employer, but whether or not that's legal is almost for them beside the point, And so for me as a journalist, I guess I would say, the only real concrete tip I could offer anyone in that is and what I tell employees often is, hey, look, I understand that you can't talk to me on the record, and that optically that would present lots of problems for you. So what records can you give me? Let's let those talk for you or for your company, and just to try to just switch it to that. And then it comes down to, okay, do they trust me enough to share something with me that I won't, that won't be attached to their name? How do we share it? That sort of thing. But that's one thing I offer people, and sometimes I think that can be effective if they understand, okay, yeah, that does kind of redirect the heat a little bit from me.
Yeah. Last thing, because I know we need to wrap, but since you raised this point, anybody that is dealing with confidential sources and documents, be sure to look at the Reality Winner case, where an NSA whistleblower, right, a military whistleblower ends up serving time in prison because a document was watermarked in a telltale way that was traced back to her. And so that is a cautionary tale for all journalists dealing with leaked documents, especially now that metadata is embedded in these documents. There may be fingerprints and footprints that you can't even see, and just be super, super careful with leaked documents these days.
Yeah, and publishing them or not at all. Yeah.
Well, this question of surveillance is a great way to end our first webinar. Thank you, Frank. Thanks a million to Matt for coming up with the idea and getting Frank involved in this crazy venture. On behalf of SABO, I just want to thank everybody. We won't be able to continue the chat, but I think we have plenty of fodder for a future webinar. Frank, I hope you'll come back. Matt, terrific job as moderator. Thank you to everybody who asked questions, and we will archive this so that members can look at it in the future, and maybe you all know how to get a hold of us and get hold of us and Frank. Thank you. This ends our session. We'll see you next time, and stay tuned.
Thank you so much. Thanks to SABO.
Thanks, Frank. Thanks, everyone.